So, good morning, everyone, and welcome to this webinar talking about GDPR and how you can turn it from a cost and a threat to a competitive advantage. This is a rerun. We met in November last time, and we did have some technical problems that we didn't notice until 11 minutes past. So we would like to ask you, the audience, if you can write in the chat, first of all, if you can hear us, and if the sound quality is decent, and also if you can see us standing here waving at you. So there's some small chat function. If you just write us a line that I can hear you and see you fine. Okay.
Excellent. Great.
All good.
Wow.
That thing's to the better.
100% improvement since last time.
Yes. Yeah, it can't be better. So warm welcome. My name is Karl-Oskar Brännström. I will start talking about the agenda and then a brief presentation of who we are standing in front of you.
Excellent.
So as notified, and let's see if we can get this to work in the manner we want it to. So we have an agenda. We will start talking about privacy-related fines and the background to these ones. We have damages and activism, a new risk landscape that we're seeing evolving in Europe and also for the ones concerned by GDPR. We have privacy due diligence, changes in company valuation. We have privacy by design that is coming up as a very important factor. We have data control as a prerequisite to handle requests. And finally, we were talking about how you make your privacy investments a competitive advantage and actually get more than just compliance from it.
Excellent.
So my name is Karl-Oskar Brännström. I'm an educated lawyer. I've been working pretty much 20 years as a tech entrepreneur, very focused on process automation, digitalization, always with a compliance flavor. Been working with data protection since pretty much 15 years, particularly in healthcare. And since a couple of years, I'm the CEO of Aigine, working with unstructured data from a legal perspective and from the requirements in GDPR. So I say warm welcome to all of you.
Excellent. And my name is Johan Thörn. I'm a senior associate with the data protection team at a law firm called DLA Piper, global law firm. I've been there for 9 years working with data protection issues from the start. So pre-GDPR actually. And I have my colleague Johan as well. Johan and Johan.
Exactly. Johan Sundberg, heading up DLA Piper Sweden's data privacy and data protection team.
Excellent. Cool. So I think we have amongst us 50, 60 years of experience working with data protection. So
like that.
So hopefully we know what we're talking about. I will leave the word to you, Johan, which is very convenient because you're both called Johan, to give some current statistics.
Yeah, we just wanted to share a brief overview before going into a few more cases. So this is some current GDPR statistics. We have seen more than 200 sanctions in relation to fines, reprimands, and orders, because that's an important point I think that should take into account. We will talk a lot about fines today and administrative fines imposed by various authorities, and also about claims for damages from data subjects concerned. But it should be remembered that supervised authorities also can order you to stop using data, for example.
Yeah.
That could be detrimental, of course, to your business if they say you can't use this register, you can't use this customer database.
Yeah, and then there is actually one decision regarding that. I think it was the Netherlands and the tax authority who has been ordered to cease processing in a certain way.
So it's interesting.
The tax authorities.
Yeah.
Oh, that's interesting.
Yeah.
Speaking about fines, we have more than 100 monetary fines. Lots of fines. Biggest fines still is the 50 million euros in relation to Google, which we'll come back to. Trying to calculate the fines, the total value is among 115 million euros. Lots of money. We have a few countries with no fines yet, 7 countries actually, among those Finland.
Yeah.
So it will be interesting to see the first Finnish case. Then speaking about why these cases come up, and we will talk about more about that later, but a common reason for a supervisor matter is of course data breaches, and we have lots of reported data breaches, more than 160,000 data breaches. And looking at the 2 other boxes there, we have the most reported data breaches are actually from the Netherlands, Germany, and UK. And Netherlands is quite interesting given the population, I would say.
Yeah, it is. And if you're interested on further detail regarding data breaches, you can also look at DLA Piper's data breach report, which is available on the website.
Yeah, just Google DLA Piper and data breach report, and you will find an updated report. I think it was updated in February, January, something like that. And the reason as to why Netherlands are one of the countries with most report data breaches is that they actually have such a regime before, prior to the GDPR. So that's interesting. I think we can switch screens.
Okay, and it worked.
And it worked. Excellent. We will, in the next slide, show a map, an overview of more cases. But I think this is interesting. We have more than 180 GDPR-related fines, and these are amongst the highest fines to date. As mentioned, we have the case against Google from the French DPA. There are a few interesting points on that case, and that is, first of all, it was the French DPA, a very powerful authority, lots of employees, lots of resources. Now, most people know that Google has its establishment in Ireland, but it has not appointed a main establishment under GDPR during the time of the decision. So that's the reason as to why the French DPA had this case. And there were two major issues in that case, and that was that Google was not transparent enough when it comes to privacy notices, and they collected an invalid consent for marketing.
Yeah, and I think we should stop there a bit. I looked at the numbers. We have 50 million euros, and you can consider that a lot of money. Of course, if you look
Depends on how you calculate.
If you calculate Google turnover, it's a small dent. It's like us getting a speeding ticket. It's not a lot of money at all. But as you said, it's an invalid consent. And if you look at the fact that Google actually delivered 285 million Android phones in Europe alone, you start understanding that their risk vector is maybe not the fine of 50 million euros. It's 285 million Android users who are now actually have the right to damages. And also, if you start talking about the other enforcements that you can actually be ordered to stop using personal data, what impact would that have on Google?
And that would be very difficult.
They will lose their European market, which of course, it's important to understand that the 50 million euro for Google is not their biggest concern. It's of course the other things that will follow.
Absolutely. Then we have two UK cases. Those fines have not yet been imposed, but there is a notice from the UK Data Protection Authority, the ICO, that they intend to fine them. And we have the British Airways case, and the Marriott Hotels case. The British Airways case is actually a data breach case, and the Marriott Hotels is also a data breach case. But the Marriott Hotels is very interesting because it resulted in, which we will speak a lot more about later, but it resulted in, as a result of a transaction actually. They acquired another hotel chain, which had legacy data stored, which were not used, I think.
No, they were just there.
Yeah, it was just there, and it was suffering a breach, and the information leaked. So that's a lot of money. We have another case, which I think is actually quite interesting. That's the Austrian Post, who, as I understand, collected data and tried to figure out the political affinity of the individuals.
And they used like salary and how big your apartment was, what car you were driving, and then from that they derived your political views for direct marketing.
Exactly. They wanted to sell that for direct marketing purposes. Trying to figure out, and as you might know, political views of an individual is sensitive data in the sense that you would need a specific exemption to process that.
According to Article 9.
Exactly, and you likely don't have that.
Probably not.
Probably not in this case. So I'm just curious about how this happened from the start, but.
Well, it was probably someone having a good idea.
Probably.
Maybe we can do that. But I think it's very interesting because what it turns out to be is that political views is, well, we know that it's sensitive. The interesting thing here is that they didn't know if it was correct. They only guessed it.
Yeah, exactly. It was a guess.
It was a guess. And then we know that although it's not correct, but keeping personal data, even if you don't know if it's correct or not, is actually a breach.
Absolutely.
And need a special consent or exceptions according to Article 9. So I also think it's very interesting.
Exactly. You're obligated to store accurate data. So there's a big chance that you have inaccurate data if you assign a guest political affinity or view on an individual. So that's a problem. Would you like to mention Deutsche Wohnen?
Yeah, I think we'll come back to Deutsche Wohnen a bit later, but let's go for the Italian one, the last one, the 28 million. That's relating to basically marketing calls made without consent, and where a large number of data subjects also were on the not to call list, so to say.
They've opted out.
They have opted out.
They thought so.
Yeah, they thought so.
Yeah. And the DPA made an estimation that this was likely involving millions of individuals who have been subject to these calls.
Yeah, I think it was very interesting. But well, I think one person was called more than 150 times in 1 month.
Yeah.
And of course, that would be very annoying if you said that you don't want any calls. But
but
mentioning this Tim case is also that the DPA actually imposed them to stop using personal data for their marketing activities. And then you can have
to define.
Exactly, in addition to the fine, and we can stare at the 28 million euros, saying that's a lot of money. But what does it mean for Italy? I think it's the biggest telecom operator.
Yeah, I think so.
That they are not allowed to sell their services anymore.
Or at least not marketing them.
Yeah, exactly. So let's see where that goes. But for sure, I thought it was very interesting. Such a big organization not taking this serious enough.
And that this, I assume that the reason as to why it came to the Italians DPA's knowledge was that people complained.
Oh yeah,
a lot.
Yeah, if you call 150 times in 1 month,
people will complain.
They will complain. And it's also interesting because they use telemarketing services. So what they concluded was that was Tim's problem providing these lists, and there was their obligation to keep personal data correct.
Yeah. So those were among a few cases of the highest fines. We can move over to the next slide, and we will have an overview here. This is of course not 180 cases approximately, but there are amongst the most interesting cases to date in our view at least. And we will mention a few cases not on the map as well. So one of my favorite cases is actually the Spanish case, the La Liga case, and I think we reflected this before we started the session that lots of cases are coming from Spain now.
Yeah.
Very active.
I think in February it was like 20 or 22.
Yeah, very
something around 20.
Yeah.
But ranging from low fines to around 80,000 euros.
Yeah,
something like that.
So I think we are seeing an increasing avalanche basically, and the Southern Europe data protection authorities have historically speaking been quite aggressive.
Yes.
So it's not a surprise, I would say, that we're seeing increasingly more Spanish and Italian cases.
And for us being in Scandinavia, we would say it's a bit surprising that we haven't seen that much in Scandinavia. As you mentioned, nothing in Finland. We have 2 cases in Sweden. Yes, this week 3 ones in Norway and so on. But we did see
a few in Denmark.
A few in Denmark, but it's relatively calm up here in the cold Nordics.
Yeah.
But we did see some disclosing numbers from the Swedish DPA just one week ago, where they disclosed that under 2019 they have been lead for 60 own initiated cases.
And that's a lot.
60 is a lot
for the Swedish DPA.
It is. Also, they are lead on 60 international ones where they have been signed lead. So that's 120 that's actually in control of the Swedish DPA. Furthermore, I think it was 610 cases where they have been involved in cases led by other DPAs. So we have 2 fines in Sweden, and we now know that the Swedish DPA have been involved in 730, I think I calculated to do. Different investigations. So avalanche, storm, whatever you want to call it, something is on the horizon, and we can see that it will happen.
The Swedish DPA also sends press releases when they initiate new investigations, and they have sent numerous press releases during the autumn. So I think we will see a lot of decisions during the spring, or at least before the summer vacation.
Yes. Yeah, I don't know if you can bet on it on Unibet, but I think that
no,
you will not get a high return on such a bet because it's very probable.
Likely not.
Yes.
So going back to Spain, I think the La Liga is quite interesting. On the same theme, how could you think this? The same theme as the Austrian Post. What La Liga did was that they have an app, as I understand it, and as a user you can use that, and you can see scores and so forth. What the users did not know when they installed the app was that they gave the consent to location tracking and using the microphone. And La Liga used this data to check whether if you were in a sports bar, whether that sports bar actually were licensed. So they use the location, and then they can use the microphone to hear if the game was on, and then they check the registers, and then they basically send cease and desist letters and claim them for license money and so forth. But this processing
Innovative.
Very innovative, but highly unlawful under the GDPR.
Yeah.
And that resulted in a fine of 250,000 euros. So interesting, to say the least.
Yeah, and going to the UK, we have on the screen there, we have the Marriott case and the BA case. I would also like to mention another case, which is quite recent, relating to paper documents.
Yes.
Unstructured data.
Yeah, where a company had disposed around 500,000 paper documents into a container, and the documents were including special categories of data to quite a large extent.
Like health data?
Like health data, yeah. And the container was unprotected, and the fine was around 300,000 euros.
Yeah, for having not safeguarding the paper documents. And it's very interesting because it goes to the involuntary destruction of personal data, which is also a breach. And this was unstructured, it was paper that got humid because it wasn't safeguarded in a good way. But I do think it's also a wake-up call for everyone thinking that deleting data is the solution for GDPR and data protection, which means that it's not, because just deleting things that you involuntarily don't want to delete is actually also a breach. So I do think that's very interesting.
And we get the question sometimes whether the GDPR actually applies to paper. And this is clear when it comes to stuff that you have stored in the computer and you have printed, does not mean automatically that the printed material is not covered by GDPR. On the contrary, it might very well be covered by the GDPR. And on the same theme, that if you collect data on paper for the purposes of storing it in the computer, the collection on paper will also actually be covered by the GDPR. So that's a good thing to take into account.
For sure.
So going down to the south of Europe and Greece, we have a professional services firm. The case is not on the screen, but I thought I would mention it anyhow. A professional services firm which relied on consent for processing of employee data, and that was of course not okay, given that the employees were in a dependent situation to their employer, and that fine was around 200,000 euros.
Yeah, and I think that we're in Sweden, and in Sweden everyone knows about the case for this school, which was also an invalid consent. It was facial recognition, a pilot that was running for 3 weeks, where they used facial recognition, and they had used the legal basis consent, and the conclusion was that you can't use that towards students because they're in a dependent situation, so they can't really decline such a question.
And that's quite interesting, because the students, it was absolutely voluntary to participate in this pilot. But theoretically, but there were like 21 or 22 students or something, and you could opt out, so to speak. But the DPA held that still, under these circumstances, given that it was for the purposes of recording your presence, it was not a valid consent.
Yeah.
And I think the other takeaway from that case is that the GDPR, of course, applies fully when it comes to a pilot.
Oh, of course.
It does not matter whether it's a pilot or a production environment.
Yeah.
Say so. The DPA will not take whether it was a pilot into account, but when setting the fine, it doesn't matter.
No. And I think it's also it was 20,000 euro, I think.
Yeah, but it was an authority as well. So
yeah, so we have lower
thresholds
for 2021 students for 3 weeks. We can conclude that per individual, that was a pretty hefty fine. It was pretty much 1,000 euro per individual. If you compare to 285 million Android users and 50 million fines. So we haven't really seen a correlation between the level of the fines and the number of data subjects.
Not at all, actually. No pattern there. What's interesting about the pupil cases as well is that it's appeal.
Yes.
So it will end up in court, and the main question is that could they provide a valid consent to this or not? So it will be very interesting to follow.
Yeah, and it will, of course, and it's noteworthy to mention that GDPR is a European legislation, which means that what's happening in Sweden has an impact on the rest of Europe as things happening all around. So when looking at what's happening, you can't just look at your own national law and the cases there. You have to look all over Europe. And as I guess you guys also noticed, it's a lot of people saying, yeah, but it hasn't happened that many fines. But when you start looking from a European level, 200 imposed cases, it's a lot. And I think that we will start seeing European news outcasts that actually has a European perspective, because we don't really have that yet. So,
but it's very, very difficult to see any trends, what different things costs, because it depends on the subject matter of the investigation and the decision and so forth. So, and there, I think there is a challenge there in order to try to align the levels of the fines for the same type of breach. But there's a work going on within the European Data Protection Board to try to find methods and formulas for calculating fines, because when looking at, for example, the school case in Sweden, the Data Protection Authority did not outline in too much detail how they actually ended up in the amount.
No,
they have said that this is the positive and this is the negative, and it's on a such level that we feel that we will impose a fine. But we don't know how they ended up in approximately 18,000 euros.
No, and although that's very practical and not very legal, but from a company point of view, when you're making prioritizations, you should know your risk vector and what money you're actually talking about. And that's this. We do need this case law, and do need to better understand where should we put the effort, what is considered a blatant infringement and what is a minor thing. And we do need to understand it in order to put the efforts where they should go in order to take the prevention work.
We should touch upon a few more cases before moving on. I think the two Danish cases, there's actually two Danish cases on breach of data retention limits. And that's very interesting, because I think it's a very common problem. You store data longer than you have said that you store it, which was the case in the design case there, which resulted in a fine for 200,000 euros. We have actually also a Danish taxi case where they store, I think it was just telephone numbers or something.
Yeah, but I think they use telephone numbers as their customer number.
Yeah, so which could be a problem as well. But they have stored them and they had not deleted them in time, which was a breach of the GDPR. And we know a lot of companies struggling with the retention issue, identifying the retention periods, but also in practice deleting the data when the retention period is over, basically.
And going back to the question regarding consistency when setting fines across Europe, we could also mention that the German data protection authorities have actually come up with a model for that. So let's see whether the
very German model.
Yeah, very
very difficult for lawyers to understand.
Exactly. So let's see if the European Data Protection Board, looks at that and takes something into consideration from it.
It's very detailed, and you have a formula for calculating the global annual turnover, and then you use various factors in order to come up with a fine. Just to put it very shortly, the problem still, I would say, that it's objective in one sense in order to try to calculate the annual turnover, but there are of course subjective factors when determining how severe was this breach.
Yes, absolutely.
Yeah, and what we've also seen is that during the investigation, whether you have you're working together with the DPA or not, has had a huge impact on the level of the fines.
The Deutsche Wohnen case is a good example of that.
Oh yeah, and their personnel, and I think this is very important. Their personnel actually saved them 14.5 million euros because they have the fines because the personnel of Deutsche Wohnen had to be so cooperative. And
there's a reduction with 50%.
Yeah, exactly. So if you're talking about data protection heroes, well, it didn't really go as it should, but they should be heroes in their own organization. So that's a hefty sum.
Yeah. Should we say something more about Deutsche Wohnen, perhaps?
Sure. I think we go there.
Okay.
So let's talk about.
Let's move on.
A bit about privacy due diligence. We have mentioned that we have the Marriott Hotel that wasn't actually Marriott, but they bought the company that had a database that leaked out on the internet.
They bought another hotel chain, basically.
Exactly.
But not sufficient protection for data.
No, and that's pretty much what we're seeing here is that on the due diligence, the privacy due diligence in transactions, is that you're actually buying a liability. And you're buying a liability that is contagious, as we will see. And also remember the fine is then calculated on group level, which means that the potential fine can be many times greater than the transaction sum. Which of course is...
and it's interesting because we have had indications that the Swedish GDPR looking at that doesn't matter where the company is in the group. Because you could potentially make an argument that if it's a subsidiary long down the chain, you should only look at the subsidiaries group, if you say so, but they don't do that.
No,
it doesn't matter where the subsidiary is in the constellation. You look at the entire group level.
And it's, I mean, if you look at the legislation for the fines, they should be deterrent. So in the line of it, and that is deterrent. That it's actually on the group level.
We were very interested to see if any company challenged that. How you calculate the global annual turnover of the undertaking, which is the term used in the GDPR.
For sure.
But of course, the DPAs have taken the more extensive approach.
Yeah, and I would say on the subject of deterrent, when we're talking about privacy due diligence, I saw an interview with Helen Dixon in Ireland. So she's the boss of the Irish DPA, and they were talking about fines towards the big tech. And she disclosed that they are investigating Twitter, they are investigating WhatsApp, and fine.
Lots to do.
Yeah, they have a lot to do, and fines are coming. She's calling everyone, their colleagues in Germany and so on, that have been criticizing them for not doing enough. And she said fines are coming, and she said that to look what is deterrent, we have to establish what is the normal level of fines on the market right now. And the only thing they pretty much have is the $5 billion fine towards Facebook in the US.
Okay.
So she's arguing that that is the base level, and now we just have to figure out what is deterrent on top of that. So
that's very aggressive.
That's very aggressive. And of course, Ireland has been working with big tech, a lot of tax money going into Ireland, but now they have another revenue stream. Let's call it that.
And the second Swedish case, which we did not mention, which was basically a lookup site where you can look up people's addresses and so forth. It was interesting because the DPA based the fine on a 3-month reference period, because that was the only reference period that they had, and then took that reference period to understand what was the annual turnover during the year. But that was like a hypothetical.
Yes.
So it's not certain that that would be the actual turnover, but they based that on the fine.
For sure.
So it's interesting.
But privacy due diligence, and why this is so interesting is, of course, when we're talking about the risk landscape, we're talking about fines. We're very focused on fines. But as you mentioned earlier, fines is maybe not the biggest problem here. You have damages according to Article 82. We haven't started seeing that.
No, but not too much.
But as I mentioned, 285 million Android users that has the right to damages from Google. That can be a very big risk factor for.
But I know that there is organizations out there in Europe who are trying to organize class action suits and so forth.
We will see it coming, and we're talking about the additional revenue stream as a private person. It's a way to get back some from
potentially the size of the damages per individual will not be too substantial, but if you come with like 1,000 or 10,000 or 100,000 individuals in the same case, it will be
if we say that it's just 3,000 euros per individual, and you take that times 285 million, and we start talking that's money also.
That's absolutely money.
That's also money. And we have activism, and this is something we have started seeing in Sweden, where actually I think the trend is pretty hard. Former employees that for some reason are keeping grudge towards their employer, who actually start demanding out all the personal data according to
And we have had a few such cases, and we are just waiting for the trade unions to wake up, basically. But we have had a few cases where individuals in such situations have requested their data, but also where they, in a dispute, have stated that the employer has not processed their data in accordance with the GDPR in order to try to get in a better position to negotiate the deal.
And we were also seeing it in situations where the company and the employer has reached a final settlement regarding the employment, and then the employee comes back with an access request, for example.
And the active access request should be said that if you don't have your information in order, they can be extremely expensive.
Yeah, very expensive. So we had a number of clients looking at the business case for implementing instructions and routines to manage such an access request, but also making the data inventory. And certain clients just said that this is, if we don't have the instructions and the routines and processes in place, it will cost basically 1 year's salary for one high-level employee to handle one request, and that's a lot of money.
Oh, for sure.
But then you also need to comply with the request within 30 days.
And you have the alternative cost, of course, because this person who costs one salary is probably doing something else.
Probably.
He's not just sitting waiting for this request to come. So you have an alternative cost that is probably much, much higher than just the salary cost.
Yeah.
We have the value. We're talking about that from a privacy due diligence perspective. Is of course that if you're not working correctly with data protection, you risk of having your share value lowered or even erased. And we have seen that too in transactions where the customer data pretty much was the asset that the company had.
Yep.
But since the legal basis and the documentation of this was lacking, they couldn't sell the company because no one wants to touch that data, especially since it's contagious.
We have had actually a few such cases where we made a due diligence and concluded that no, you don't have a sufficient legal basis to store this data. And then the value might not be actually zero, it might be a negative amount.
Yes. Yeah, and that's hard as a shareholder. So that's from value. And then I think we should put up this, which is actually right now the absolutely biggest one. We saw this in a Forrester report. What is the reason for your investing in privacy right now? And the biggest part of the CIOs and the companies and the CEOs actually answer trust. That if we're losing our customers' trust, we can't do business.
Exactly.
And since the awareness level is going up all the time, we can stare at these risk vectors and talk about money and so on. But what does it mean for Google if people are not allowing them to use their personal data? Well, they can just stop all their business models. So I think it's very important to keep in mind that the personal trust and the trust that people have in your company is a prerequisite for dealing with personal data and therefore creating customer offers.
Absolutely.
Yeah, and I think we saw that also a couple of years ago before the GDPR that, you know, a lot of companies having consumers as customers, they were having trust on their highest level, so to say, for doing a diligent job on this.
Yeah, so that was the main argument. They were more concerned about their brand and the customer trust than fines, than damages and so forth.
And I think it's reasonable. And it should be the compelling reason for actually doing this. It's to get the trust.
There have actually been reports also that if you have a significant amount of consumer or customer trust from your customers, they might actually be more willing to share data with you.
Of course.
Because they deem that they get value and they trust you in handling the data correctly. So it could actually be a win-win in that situation.
So it's up there, and it's very important to mention. So should we say something about personal liability? This is a discussion coming up in Sweden. So I know that you've been working with some what is called employment law. Too.
As well.
Yeah, to try to understand the risk of personal liability, and this is pretty much based in the Article 29 group, who got the question before GDPR was presented.
In their guidance.
In their guidance, can the DPO be personally liable for fines under the GDPR? And they answered no.
It was not a nuanced statement, but I think the question was basically, is the DPO responsible for compliance? And the answer is of course no. It's just a company or organization. And could the DPO in such a case, based on that, be personally liable for the organization's lack of compliance? And that's what they responded, and they said no, but you would need to look at the local legislation in that regard.
So we pretty much looked at Swedish tort law,
Yep.
and it should say that this is different from country to country. And what we concluded is that DPO has some kind of theoretical risk, but it's very low. It's very theoretical.
The threshold or the bar for actually getting damages from an employee in Sweden is very high.
Oh, and I would say I think it's pretty much the same in all of Europe. We are protecting our.
Now we're not qualified in other European law, but if you say so, we trust you.
Yeah. And looking to Sweden, for example, when it comes to liability of an employee towards the employer for damage caused while doing your working tasks, it's pretty much intent or gross negligence which is required.
And that's also why we brought up the CEO and the board of directors in this image, because well, a CEO normally it's not gross negligence, it's not with negligence. I don't come to and say that
for breach of contract.
Exactly, and they do have a contract which is probably talking about damages. For the board of directors, it's in Sweden at least, it's directly to negligence towards the operations of the company. Normally there is no limitations in in their liabilities. So yeah, just to show it that if you're going to do something for personal liability point of view, look at the board of directors, and the CEO should really look on their risk factors towards that part.
And you raised the good point as well. When looking at who to target, you look at who's got the biggest pocket.
Oh yeah, for sure, for sure.
So deep pocket theory.
Yeah, and they will probably be found by the CEO and the board of directors more than
rather than DPOs. Yeah.
So going forward, we're talking about privacy due diligence and why this is so important. And well, one point I have is that it's contagious, pretty much like environmental liabilities. And if you're buying a factory, you will take over the land and any things lying in the land. And it's pretty much the same thing with data protection. So if you buy a company, you do have the fines, the damages, and the requests, and the cease operations, and so on. But from a contagious point of view, if you're buying this company, you will see that fines are actually calculated on group level. You will see that the damages, you have a much bigger exposure to damages, also requests and the badwill. But the interesting thing is the cease operations will probably just hit that part that you just bought. So the cease operations, it's pretty stable, but everything else is growing if you acquire a company into a larger structure.
When it comes to damages as well, under the GDPR, the individual can choose who to target.
Yes.
So you can target the controller, but you can also target actually the processor, even though it's the controller's fault.
Yes.
So it will be interesting to see there if you also target the company with the biggest pockets and the biggest insurances and so forth. And then they need to settle this amongst themselves.
Yes. So privacy due diligence, we really think that's coming and will be a big thing in the years to come. I would say from my point of view, not being a practitioner lawyer, I would say don't buy a company without checking their data protection work.
No, but totally agree.
Yes, good.
And it's actually, as a general reflection, is that looking at transactions that our firm do, GDPR and data protection and compliance is coming up as a red flag issue. Yes, more and more.
Especially since we identified some personal liability on the board of directors level, which means that this can really hit people personally. So the privacy due diligence, it's a bit of math and reality. Buying a software company, you do have the processes, the code convention, and then you have the code review that is actually determining the distance between what they are saying and what the reality is. The same thing with the legal issues. You have your business model, your price list, your customers, and then you look into the agreements. What is the reality? And that's what we're saying. You have to start doing with privacy. You have to start looking at the processes, the records of processing activities, and so on. And then you have to start looking at the actual data, what is actually out there, in order to understand what is the distance and thereby what is the risk.
And that's a difference between a normal legal review, because of course you look at agreements and so forth. But when it comes to privacy, you need to look at what do you actually have and why.
What's the reality?
What's the reality in order to determine the risk, because it's very, very difficult otherwise.
It is. And of course it's extremely time consuming going through all the data. So luckily there are tools in the market.
Or conducting interviews or something.
Yeah, to better understand. So with something about privacy by design, we mentioned the Deutsche Wohnen case, which I think was very interesting. What is the thing with the Deutsche Wohnen case is, of course, that there were no breach. So pretty much what they had, the German DPA called it the data cemetery. So they find
there was no personal data breach, no leak.
No leak, exactly. No leak at all. But they pretty much
a breach of the GDPR.
Oh, for sure, 14.5 million euros breach. So they pretty much find a hard drive with a lot of files on it containing personal information, and they concluded that, well, they can't redact things and deduct the personal data in time because they simply haven't documented it and they don't know where it resides.
And it was technically impossible, I think.
Well, they called it technically impossible because they didn't have any technology to do it. And I bring up the Datatillsynet
Norwegian case?
The Norwegian case that is very recent. I stumbled across it just a couple of days ago, which are actually relying a lot of Deutsche Wohnen case. They see the Norwegian DPA see a lot of similarities. There's no personal data breach. They lack the technical ability of taking away the personal data, and this was from the road service, so it's for the toll stations, where they actually kept the license plate number, I think, time and location, and they kept it for more than 5 years. They have a legal obligation to keep it 5 years for accounting reasons, and they kept it longer. And this, I do think it's interesting because it was 4 million Norwegian crowns, and well, compared to 40.5 million euros in Deutsche Wohnen, but in Norway it's actually capped at maximum 10 million. So in Norway, yes. So it's for public entities. So it's actually 40% of the maximum fine level towards this breach, and it really put the finger on the need of privacy by design also for your legacy data, because that was the case in Deutsche Wohnen, and it's the case in Norway now. And I think it's interesting for case law because the Norwegian DPA is actually talking a lot of the Deutsche Wohnen, the conclusions made by the German DPA.
They use the same rationale.
Yeah, and they're even making references to it.
Oh, okay.
So
I have not reviewed it.
Yeah,
it's very interesting.
It's very interesting. So we see some cross-border case law coming up, and that's interesting. So we know that not fulfilling the privacy by design is 40 to 100% the maximum fine. And
this was probably a legacy system, basically.
Oh, this was a legacy system. This was an old, and that's the same as this procrastination, I call it, because the public road service in Norway, they knew about the problem. And they went to the vendor and said, this is a problem. They said, yeah, we know, but we need money in order to fix it. And they said, no, we will not give you money right now. So they had actually postponed the solution. So they were aware of it and they hadn't addressed it. And I would say that the Norwegian DPA looked very strongly on the fact that you are aware that you have problem with your data, but you have chosen not to do it. And that makes it so blatant.
I can imagine that there are various issues in that. First of all, of course, the cost issue that the vendor thinks that the customer should take the cost.
Yes.
Of course, the customer thinks that the vendor should take the cost because the vendor should supply GDPR compliant system. So that's interesting to see who should bear the costs in practice.
Yeah, we will see where it ends up, this 4 million Norwegian crowns. But what we do know is knowing about a problem with your legacy data and the privacy by design and your abilities to both answer requests and redact.
And I have not reviewed the case, but it would be interesting to know whether the public authority in this case looked at alternatives in order to try to find another vendor, for example, to migrate the data to a more compliant system.
It's pretty well. There have been a lot of meetings, and pretty much all the meetings ended up and they've not come to a conclusion how to solve it. So it got postponed.
I don't know if it would have made a difference in this case, but it would be interesting to see what were the practical realities in order to try to find a different solution than just this vendor.
And probably it would have been cheaper for them just with their vendor to solve the problem. And that was pretty much the same with Deutsche Wohnen. They were aware of the problem, but they hadn't succeeded in solving it. And that's also.
But they had started in Deutsche Wohnen.
Yes. Yeah, they have tried. But trying is apparently not enough if you don't have a plan that can show that you will succeed. So just doing something is not good enough. You have to do something that will actually resolve the problem.
Interesting.
So I think it's very interesting. And as we said, no data leak of personal data at all. And very high level of fines. Although we are staring at the 4 million, it's actually 40% of the theoretical maximum fine. So why is this difficult? And I will start talking about a bit what Aigine is doing.
Of course.
So we're coming across this Deutsche Wohnen and data and so on. Well, for numerous of factors, and what we concluded when we start looking at the scenery of available tools for actually solving this data protection problem, specifically for legacy data, we concluded, well, unstructured data is not regulated, which is pretty what wasn't before.
Not in Sweden, at least.
Not in Sweden.
In other countries.
In Holland, as you mentioned, they had similar legislation before, also in Germany. But in Sweden, the unstructured data, and then all of Scandinavia pretty much. And apparently in Germany, Deutsche Wohnen had unstructured legacy data that they didn't have control over. We have this battery of rights we're talking about data subject requests, we're talking about
data portability,
the possibility to get corrections and so on. You have the absolute demand for documentation, that you shouldn't document it afterwards. You should have everything documented, and then just the fact that the processing, storing data is also processing.
Absolutely.
Which means that if you have it on a hard drive, or even as in the UK, if you have it in a container, you should have it documented. You should know where it is, and you know what kind it is, and you should have your reduction period.
The documentation, I think, is a good point, because pre-GDPR legal framework, it was, so to speak, sufficient to just comply.
Yes.
Which organizations didn't do, but to a full extent. But under GDPR, it's not sufficient just to comply. You would also need to document your assessments and how you're complying.
Yeah, and it's pretty well described in Article 30. And it's not it's not just, okay, we have personal data residing here. You also have to write what kind of personal data it is, what type of register it is, how long you will keep it, what the purpose is, what the legal basis is, and so on. So it's a lot of documentation, which creates a huge hurdle. That's pretty much what we saw when
managing that in practice, because the challenge that we have seen with our clients, that many have done a great job in inventorying and trying to find out, setting the purposes of how long do we use the data, why do we use this data, but keeping that alive.
Keeping updated.
And keeping it updated is a huge challenge.
Yeah, and the documentation, the DPA actually has the right to get it directly.
Yeah, they can request all data that or documentation that they need.
Yes, and you have to comply. And of course, from our point of view, the broader definition of personal data, that it pretty much changed, and from a technical point of view, it changed substantially, going from previous legislation to GDPR in Scandinavia. And I still have this small example to display that, and that is
Tesla car.
That Tesla guy. So what's his name?
Elon, still
It's
Elon Musk.
still Elon Musk. Yeah, I already done this. Next time we have to bring in someone else.
Yeah, I think so.
Yeah, but just saying that Tesla guy and you being able to identify him as Elon Musk is actually pretty much the definition of personal data in GDPR. So what they added was the in combination. So it's any information in combination with other information that makes it possible to identify someone, which means that it's very broad and it's really cognitive, because it's your brain working with associations, and it's also contextual, which means it depends in the text whether it's personal data or not.
Which means that if you have, for example, lots of emails and you have not spelled out the name of the employee, but if everybody knows who that is, for example, you know that guy, that guy in the reception, or the guy in that corner office, it will still be personal data.
It will still be personal data, and for sure, from a technical point of view, you end up in a situation that's a huge difference between a date and a birth date, and traditional technology cannot make this difference because they look exactly the same. The only way to understand if it's a difference is to understand the context where they show up. So if it's your name, a comma, and then a date, and then a comma, it's probable that is actually your birthday. So that's contextual. Humans understands that, but traditional search technology doesn't. So that's why we in Aigine, when we created our solution for this together with IBM, we looked at the cognitive and imitating these cognitive abilities that we as humans have. So what we pretty much did, and I will explain how do we solve this problem, is that we are using StoredIQ from IBM. It's a data mining solution, so it can read all the data, no matter what format it is, and what data sources it is.
So it looks at your data repositories.
Everything.
Okay, it scans everything.
It scans everything. It reads everything, and that's where StoredIQ are so strong, because it's over 1,000 file formats. You probably don't even have that software that can read that, but StoredIQ will be able to actually read the information within the file. And since we're talking about legacy data, from our point of view, that's the biggest thing, is to be able to read everything, because otherwise you will lose.
Old file formats.
Well, when I started out, I don't know, we concluded me and Johan Sundberg, we are the same age. When I started, it was WordPerfect.
Yeah, absolutely.
So, and there are still residing WordPerfect files out there. So we're using StoredIQ, and that's traditional technology, and as I said, that can be used to find GDPR-related things. So in the next step, we're actually applying our own artificial intelligence, our algorithms, to create this draft of the records of processing activities according to the demands in GDPR. So this is both personal data, that guy, as you mentioned in the reception, have the birth date compared to the date to contextually understand where this personal data resides. But we're also using algorithms to describe the redaction period, the purpose, the legal basis, and so on. Well, everything you have to document according to Article 30. But this is artificial intelligence. And as you know, artificial intelligence is developing. So in order to secure the quality of that work, we have
training.
You need to train it and you need to control the quality of it.
Yeah.
So that's why we're involving humans in order to quality check the control and the work of the AI. So we have a workflow tool that is actually presenting the document, the content from the document directly in the web browser. So you don't need WordPerfect in order to be able to review the WordPerfect files.
So it's displayed in the system.
Yes, it's displayed directly in the web browser. And of course, this is the work of the AI, so it has found the obvious name and address and so on. It also found the birth date because it's contextual. But also the combination of profession, year, and company, which in most cases can be used to identify someone. So as you said, you're the lead for the data protection in the DLA Piper in 2020. Well, it's information that can be used to identify you. So there is a quality check, and in order to do this, we are also educating the humans doing this by displaying a knowledge database directly from the DPA or customer-specific manuscripts, to train them and to educate them into what is this actually about. And finally, you're verifying the work of the AI. I mean, it's the best guess. It's AI we're talking about. What might the purpose be? How long is the redaction period, and so on. So we get full control of the information and the personal data residing within pretty much each file. And what
this is a first check, I assume, when it comes to the legal basis and so forth. I would assume that you would need to have a legal verification on that as well.
You will be able to sort it out and to start seeing where it is, but yes, and this is an iterative process. And that's pretty much what's important in this, is that this verification that we get by humans, we're actually using them to train the AI. So this is happening on-prem. We're coding everything with, this is what we succeeded with IBM, to actually code things on the customer side and use that to train the AI. And that means that all our customers can train the same AI, so everyone is benefiting from the quality control and others. So we are increasing in an iterative process, training the algorithms to increase the performance. And of course, the best efforts that we've talked about, we do know that if you should put a solution in place for this, we saw in the Deutsche Wohnen, they tried, but they failed. If you're actually aiming for having this documentation updated, we do know that you will start avoiding fines, damages. That will.
I think the manual work point is very good.
Yeah, but if you have started trying to figure out how to do this manually, you will find that it will take too much time.
And I would say that most companies that we have worked with, they have of course focused on the structure.
Yes.
On the systems and applications and databases and so forth. But not all have good solutions for actually mapping the unstructured data.
And we see it increasingly important, since the privacy by design is also hitting all the unstructured data that you have. And the manual work, you have to reduce it. And the thing is that since we're iterative process where the AI is actually trained, we do have performance that is continuously improved. So the efficiency is actually increasing all the time. And we do see a point in time where the AI will be as good as an employee actually in doing this. Not necessarily smarter, but not making mistakes, because that's the thing with humans. On page 13, we start having some fatigue for what we're doing. Not you, of course, your lawyers.
And the biggest reason for personal data breaches.
Yes.
Human error.
Yeah, human error. And it can be performed by non-legal professionals. So as you said, but for some legal basis, you do need to make an investigation. Totally agree with you, but for the most cases,
but just for checking whether this is a name or whether this is a birthday.
Exactly.
Of course.
And of course,
you don't need a lawyer for that.
You don't need a lawyer for that, but
fortunately.
But you do probably you would like a lawyer to look at your manuscripts in order to give guidance for the people doing this, and this is of course to provide continuous and privacy training for the one doing it. You get it out to your personnel. And what we normally say is that the only way to solve this challenge is to stop having these bad habits or doing things the same way as we always do. And the only way to go there is to have people change their attitude towards.
And I would say that that's the biggest issue actually with GDPR, is changing bad habits, changing routines, changing the ways of working and so forth. Because you're used to doing what you're always doing.
Yes.
But now you need to change certainly in some ways in order to ensure compliance.
And it's a bad example, but for my grandfather, when we were out sailing, he pretty much threw the beer can directly in the sea. It's 30, 40 years ago. I don't do that because something changed in our attitude towards environmental problems. And it's pretty much the same thing with data protection. We have to change the way we're looking on privacy, so you don't send that email containing sensitive personal information. But the only way to really achieve that is for people to react themselves. I shouldn't do this. And we can put control systems in place, of course, but the key is to actually change the attitude.
Training is very important.
It's very important. From a governance point of view, of course, this is the most important. It's when you have made an inventory that Deutsche Wohnen hadn't done, you start having these abilities, which is, of course, demanded by GDPR. It's a very intelligent legislation. You need to monitor your data sources according to the documentation. We can do that with artificial intelligence. We have to manage the data subject requests, both the right of access, but also racial reputation and so on. You have to move files to the correct security level. Also from an access management point of view, everyone shouldn't have everything, and this is pretty much when we're talking about unstructured data, how it looks. Everyone has access to L:, where we have all the information.
We have had a few cases on exactly that point. For example, the Norwegian cases on the map was actually a file stored in an unsecure location.
Yes.
With not sufficient access management.
So access management and information security is a vital part of data protection, and it's not separate. And for us, it's pretty fun. And
but then you need to know where you have it.
Yes, you need to know where you have it in order to deal with it and don't have the access going. Of course, we can remove personal data when we lack legal ground, and this is important because everyone thinks they have to remove all the documents and all the information just because they don't have the right.
You just need to remove the personal data.
Yeah, because GDPR doesn't govern information or data; it governs personal data.
Exactly.
So this is also one thing that is very important when it's time to do it, or when someone asks for the right of access. You cannot disclose other people's personal data.
Not as a main rule.
Not as a main rule, which means it's tedious manual work.
Yeah, very much so.
Away all this.
And you would need to make an assessment and so forth.
Yeah. So finally, more valuable data can actually be saved because we're separating personal data from data. So it's information management and personal data management is not the same thing, and we tangle them up, especially in our unstructured data. And of course, to have real data-driven innovation, you have to separate them and deal with them separately. So that's what we are doing.
Interesting.
Yes. And
we should wrap up.
Yeah. It's so fun to talk to you guys. I don't see the time passing.
We should do 2 hours next time.
Yeah. So we talked about competitive advantage, and we did mention the trust things, which I think is very important. It's more and more companies seeing that trust is vital for future business.
Absolutely.
We do have the lower cost. If you're in control of this, you will have lower cost both when you get requests and whatnot.
Yeah, absolutely.
But also with data storage.
Yeah.
So I think cost is an important thing.
Absolutely.
If you invest in data protection, you gain a lot of things. Lower cost
for storage.
For storage is one of the things. Well, it goes without saying.
Yeah.
Higher confidence in the market, in the stock market, and whatnot, if you're actually doing this in a correct manner.
Yeah, in relation to various stakeholders, could be customers, could be shareholders, it could be a potential buyer.
Yes.
Absolutely.
No bottlenecks, and I think this is, we talked about this 1 year salary.
Exactly, and the 30-day time to comply with.
So that pretty much means that you need 12 people that is doing this during 1 month, and that would create huge bottlenecks in the normal business because these people are not sitting waiting. I think that's the main thing to understand, that they are not sitting just on a bench waiting for this to happen, which means that complying over time will create bottlenecks in your normal business, and you will not have that, which means that you can be more lean, which is of course more efficient. Increased productivity. I saw a report, I think it's 10 to 15% of an employee's time goes to looking for information.
I know. Googling in your Outlook.
Have you tried that?
Yeah, lots of times.
Yeah, and
trying to find this presentation.
Yeah, but it's a good example. So
lots of time.
Lots of time goes to this. So data classification and information control, which is actually what GDPR demands for personal data, As a spin-off, you will start getting that for your data, which means it will become more structured. You will find it easily, and therefore your employees will become more productive.
Yeah.
Which is directly on the bottom line. Yeah, productive employees. It's pretty good. And of course, this is something for me working with IBM, data-driven innovation. It's a huge benefit, and we're talking about bad habits. There are so many companies that come to say, yeah, but we solve it by deleting the data.
But then you can lose the value of the data as well.
I mean, it might be illegal, as we talked about the involuntary destruction of personal data. It might be illegal, and you lose all the value. So I think that the analogy of data being the new oil, I think it's pretty good because it's very valuable, but you have to handle it with care.
Yeah. So we usually call it the new uranium, actually.
Uranium.
Yeah, the new radioactive material.
Yeah.
So it's very valuable, but you need to handle it with care.
Exactly. And that's pretty much how we see it. So we do think that investing in this, and we are talking about the second wave in GDPR, and that's also what the Swedish DPA are talking about.
Yeah, absolutely.
We see that in the marketplace. A lot of companies are revisiting their rest list and start understanding that they didn't really do the checkbox. And
it's a compliance issue over time.
Yes.
It was not just a one-time effort.
And that's pretty much how it's constructed. It's like with working environment, it's a continuous improvement that is actually demanded, so you will never be done.
No, absolutely. No, that's true.
And it's important to keep that in mind. So you have to set up your practice in order to continue.
The same way you never cease to pay taxes.
You don't?
Until you die.
Okay. So I think that concludes what we had to say.
Yeah.
We're pretty much on time.
More or less.
Yeah. We do have if someone wants to stay online. If you want to ask some question, we can try to see if we can get some chat before we turn it off. Yeah. So if anyone has any questions for us, please write it. We have the questions. We have some answers. So I don't see anything showing up there. Or we don't understand the technology. That's also an option. Well, I hope you all enjoyed this, and thank you once again. It's always very nice to chat with you. And yes, we will publish this.
Yeah, post it in various channels.
Yes, and if you don't have us on LinkedIn, please connect.
Yeah, absolutely.
So you become part of our network. So thank you.
Thank you.
Thank you very much.